Welcome to part 4 of our series titled The Life Cycle of an Early Stage Tax Dispute. Part 4 is in relation to ongoing correspondence with HMRC, and we set out some practical tips on how to deal with that in the course of a dispute. So to go back to our illustrative timeline here that has become familiar during this series, we are now at the stage of further correspondence that you can see 5 circles in. So depending on how difficult or unclear the technical law behind HMRC's challenge is, or even just depending on the tactics employed by HMRC, you may find yourself exchanging a number of letters. This slide sets out a few practical points to remember when exchanging that correspondence. Firstly, be aware of the taxpayer's rights and the limits on HMRC powers. It is useful to step back and consider why there are formal requirements in the course of the conduct of an inquiry. Those requirements are designed to provide the taxpayer with finality in their return. Individuals and companies have the right to expect that after a certain amount of time, their tax affairs for a certain period are final. Equally, HMRC wants certainty and the ability to run an efficient tax collection process. The statutory process is ultimately there for the benefit of both parties. So when HMRC makes requests or utilises its powers, it should be checked that HMRC are acting within the proper limits placed on their powers. Those limits can be time-based, behavioural, or knowledge-based, and we'll come on to discuss some of them in more detail in this series in relation to discoveries. I think there has historically been some stigma attached to winning a dispute with HMRC over a technicality on the procedural points, but I don't necessarily think that there should be. It is important that these processes are conducted with due process and that taxpayer rights are upheld during the course of a dispute. Secondly, check the inquiry is being conducted in accordance with the law. Now, this is on a continuation of the theme I just discussed. It is worth checking that the inquiry has actually been opened or that any assessment that has been made is valid according to the statutory requirements. A good reminder of this was a 2020 first-tier tribunal case called Credit Suisse Securities. In that case, the inquiry and assessment got all the way to the closure notice stage when Credit Suisse argued, hang on, actually, there's not a valid inquiry here and HMRC are out of time to raise one. What had happened is that there had been a continuum of correspondence where HMRC hadn't quite got to the inquiry stage yet, but had been asking questions about the bank's payroll tax return. There had been a lot of informal correspondence, just by email, with staff in the bank's tax department, and partway through that process, the person handling the investigation at HMRC changed. After getting to the point of HMRC issuing a closure notice, which amended the returns, by which time HMRC were out of time to open an inquiry, Credit Suisse argued that there was not a valid inquiry, and therefore the closure notices and accompanying assessment were not valid. The tribunal agreed. Frustratingly for HMRC, the first-tier tribunal acknowledged that if it had been required to decide the underlying substantive tax issue, that HMRC would have won, and therefore the procedural error in this case came at a real cost to HMRC. Do not volunteer information naively and freely. HMRC can only request information that is reasonably required. HMRC are not permitted to require the creation of a document, only to request the provision of existing documents. What is reasonable has to be considered in light of the facts of the case, but HMRC have to be able to show why seeking the information may help decide what the correct tax position is and whether the nature and degree of the burden placed on the person who is being required to provide the information is reasonable in the circumstances. Further, as discussed in the previous session regarding informal inquiries, the client may be subject to confidentiality obligations to shareholders or employees or others, and there may be GDPR considerations to take into account as well. Play out tactics and possible outcomes and refresh this as the inquiry progresses. There could be a number of technical arguments in the mix that could be raised by either party as the inquiry progresses. There is often a form of standoff where both HMRC and the taxpayer try to get the other party to reveal their primary technical arguments in full first, in order to be able to be the party to rebut first. Once a party does reveal what they consider to be their strongest primary argument, this will inevitably expedite the process as it moves the correspondence from discussion territory to we disagree territory. It is worth modelling out the economic impact on all stakeholders of the various different outcomes during the course of the inquiry as this could help shape how certain arguments are framed and also prepare stakeholders for the impact of various outcomes well in advance. Ensure conduct is not in penalty territory. Respond promptly to HMRC correspondence. There are no statutory time limits for responding to HMRC's general correspondence letters in the course of an inquiry, but HMRC usually suggests a deadline for responding. It is best practice to let HMRC know if you cannot meet that deadline. I would recommend cooperating with HMRC's requests and being helpful in explaining why certain requests cannot be met if that is the case. For example, say HMRC have requested certain information that pertain to a shareholder, and the taxpayer is bound by confidentiality provisions in a shareholders' agreement that only allow disclosure to a tax authority as required by law. The taxpayer should explain to HMRC that it is bound by confidentiality provisions and that unless HMRC uses its powers under Schedule 36 to require disclosure, the taxpayer would be in breach of those confidentiality obligations by providing such information. HMRC should be asked in such circumstances to acknowledge in writing that the Schedule 36 notice is not being issued due to a lack of cooperation by the taxpayer. Finally, calls and meetings with HMRC. There is no legal requirement to attend any calls or meetings that are offered by HMRC during the course of a dispute. It should be considered whether it is in the best interests of the taxpayer to attend such a meeting, including whether it is the right stage of the dispute to do so. A detailed agenda prepared in advance of the meeting is essential. Taxpayers should take their own notes at meetings and on calls with HMRC. If HMRC do produce their notes, review these carefully. Generally, it is not recommended to approve or sign HMRC's notes.